Hey everyone, Harry here to talk about Trump's reply to the recusal motion of Judge Chutkan. So recall, they came in and cited a couple statements she had made in sentencings of defendants from January 6th. And those defendants tended to say things like, we shouldn't get clobbered when the people who did it are still at large, etc. And she made two statements, statements in two different sentencing. One that said something about the person who did it hasn't been charged, and that was obviously Trump. And then something that spoke to higher ups. And that's the basis for the recusal motion. Now, the government, Special Counsel Smith, came in and said, forget about that. This happens all the time. Judges are supposed to do it. And there's a doctrine, the intrajudicial statement doctrine, that says when you're just expressing opinions that you, in the sort of normal course of litigation, everyone understands judges are human beings. They look at the person in front of them and form judgments. Indeed, that's what you're supposed to do when you sentence someone. Give the kind of whole reaction and look them, in the eye and say, here's why I'm giving you the sentence that I'm giving you. For instance, we have one judge who sentenced the Proud Boys. The United States asked for 33 years. He gave 22 because he said, I think the guidelines overstates things. So, that's the job of a judge, is to explain. They're sort of representing society now, exercising discretion, which the law gives them. And they need to explain to a defendant and for the benefit of society why they're imposing the sentence they're imposing. And the law is, when you're doing your job like that, it's something like rarely, if ever, could that ever be a basis for challenging someone. All right. So Trump, though, has come in and said that doctrine, it shouldn't apply, the intrajudicial statement doctrine, because here, this isn't Trump's not being charged and the like. That's not something that comes to Chutkan as a result of her litigation, or adjudication, I should say. Judges adjudicate, litigants litigate, of the sentencing. That's just stuff she's, knows from in the press. It's her own personal opinions, like any of us would have, about how much he merits punishment and the like, because we listen to the news. So here, court, and this is Trump's lawyer arguing to Judge Chutkan herself. He hopes maybe to have an appeal way down the line after the trial, but he's arguing to Judge Chutkan herself and saying, Judge, this is different. It doesn't apply, and with it the presumption that almost never can you get recusal, because these are really more personal opinions that you've gotten from watching the news, rather than impressions from having had the defendant in front of you. So that's sort of a legal question. And it's interesting because, being a legal question, I think at this point, Lauro, who is being, basically a kamikaze pilot, he is continually putting himself crosswise with the judge, and, in front of whom he's going to have to try the case. But I think he's thinking about appeal, and this is sort of a way of framing a legal issue, which might have more bite for a court of appeals if and when it ever hears this. Just to summarize, if Trump, by some miracle, and it won't happen, is acquitted, all these motions and the like will go away, because he won't be able to be tried again. If he's convicted, nearly all of them, that is the ones that can't be appealed before the trial, will be preserved, and he can make them then. So what Lauro is thinking is wanting to say, let's say a court way down the line would say, yeah, this really is an intrajudicial doctrine. Now, the way for Chutkan to handle that, and I think she probably will, is to make alternative findings that, this is, as the United States says, part of it. But even if it weren't, doesn't rise to the level of recusal, et cetera, et cetera, et cetera. So putting it on an alternative basis so a court of appeals wouldn't be able to overturn it. That's really what's going on in a lot of this fast skirmishing now and pretrial motions is looking at dredging up basically issues for appeal. All right. So anyway, the reply here, and now things are set up for Chutkan to decide. Ought to come soon, but we don't know exactly when. That she should recuse herself. Almost certainly she'll say no, and she'll reject the argument that these are somehow not covered by the intrajudicial source doctrine, which means that she sort of did them as part of her sentencing of defendants because, says Trump, they're really just your stray personal opinions that you injected in. So look to her to say something like, I don't think that's right, but in any event, they don't rise to the level of recusal. And now John Lauro has, if anything, dug himself into a deeper hole with Judge Chutkan, but I think he's decided that's the role he's going to have to play, and hopes that he'll either make her kind of become intemperate. Seems very unlikely to me. She's a cool customer. Or just, get a ruling that will sometime way in the future, and who knows what lies between us and that, serve as the basis for an issue on appeal. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.